When we left last time, we were engaged in a discussion about are there principles that guide you with respect to the practice of law that go beyond what you may learn with respect to what the substantive law is in a given subject and what the code of ethics require. I want to ask you about just a couple things before we close out this article. I've got a line here which says that we're creating mercenaries equally able to fight whichever side has paid their fees and who are indifferent to the consequences of their actions. Is that who you are?
I would hope not.
Well, I know you don't you don't like it when it's cast that way, but isn't that method of law school instruction, is that you're supposed to be able to argue both sides, to be able to advocate even for those whose causes you don't necessarily believe in, right? I mean, I know some professors, some law schools teach that you should be dispassionate advocacy, right? You shouldn't let your feelings control your arguments, and that's probably not a bad idea anyway, or is it? Your feelings, your personal strength of conviction with respect to your client's case doesn't matter? Because I'm wondering about, are you just mercenaries equally able to fight whichever side has paid their fees, who are indifferent to the consequences of their actions? It's not your responsibility what carnage you leave at the end of it. I know, I'm sure you don't like it put that way either, but that's the adversarial system. We fight fairly, but fight. And who wins or loses is someone else's decision, not mine. And if they get it right, great. If I win, even better. Is that Louis shakes his head and says, yeah. I mean, and that, huh?
He's always for the money, Louis.
Well, in fairness to Louis,
yeah, but that's how you have to.
In fairness to the position, I mean, that is most of what law school training tries to do, doesn't it? I asked you when we started, do your personal beliefs matter, or it doesn't matter anymore? I can't imagine any of you, certainly in this room, would advocate for child molestation, but someone's going to have to represent them in this room or outside, right?
I mean, I guess a good analogy would be if you were a doctor and you had someone come in for an emergency and he was shot, but he was someone that you don't necessarily agree with, whether it's for his religion or if
he was the current person that killed Marguerite, but now his life is in your hands.
Exactly. So it's sort of like you can't not try to save him just because you personally believe.
You still have to do, you still have to do a job at that point. You're a doctor. You're not somebody who's the moral.
I got to do my best.
Well, that's the old.
My hands are a little tired right now. I don't think I'm going to kill myself on this.
That's the
no. Is that? I agree, and I agree. But and that's an excellent analogy. But
like we said,
for real, you're going to raped and murdered Marguerite. Now I'm going to go out of my way to try and save this scumbucket.
Well, I don't think you're going out of your way. I think you're doing your job, which is to provide medical service.
Provide my extraordinary surgical skill to save someone who doesn't deserve it.
I don't think that analogy works.
Why not?
They could always go to another lawyer. It's not time sensitive as much as like your health is. Like an emergency room doctor.
Emergency room, you got to apply it. You got to do it because you're the only game in town. But what happens if you find out down the road, you didn't know at the outset, but now you got the client, and it turns out this client is horrible. The worst human being in the world. And you know what?
You can recuse yourself.
I'm not staying up till 2 a.m. rereading crap for this guy. Or are you? Or are you going to tell me you are? You're probably supposed to tell me you are, and I'm supposed to tell you you should. But are you?
when you said we're not necessarily agreeing with what he did, we're trying to make sure that the other side, dots their I and crosses and T's.
But let me go the other way with it. Aren't there some cases you're going to feel more strongly about and work harder for, and because you know that this this fight is worth winning? No? Are you going to say, really? Are you telling me, no, I'm going to give them all 150%, 180%, 200%?
You try to give them all 200%, but there's some that are going to hit home with you no matter who you are.
Isn't that the practical reality of it? That some mean more because of everything else that brought you to who you are, no? I mean, if we were just machines, it might be nice to think of, oh, we could do this. And by the way, what about the second half then? Let's say you can. You really don't care what the consequences of what you do are? That doesn't matter? So you break up a family, what's the big deal? So you...
We got to give us a better example than you just break up a family. Are you?
Well, I'll use that example that I told you about that struggled with me. There was a really horrible adoption gone sideways for various reasons. But and there were siblings involved, and I have 3 brothers and a sister. And so if I won, what was going to happen was those children, which we weren't aware of at the time, would be split up. The family, the siblings would be split up because they were with 2 different sets of parents for an extended period of time. And so if you win, consequences are that they may never know their siblings. And to me, siblings are important. Maybe to you, your siblings are important, right? So you're gonna, if you win, and by the way, my clients, it's long. These children, parrot, by the way, just to up the ante, it's a parrot. Was a parrot. Probably can't give so much detail because I can't give so much detail. But there were reasons, additional reasons why it resonated with me, and if we were successful, then the siblings wouldn't be together. Which normally that always drove me crazy with my wife's cases, is that oftentimes when DSS would come in, and if you have 4 kids, they can't put them. At least they say they can't put them together. And as a practical matter, a lot of people aren't going to take 4 at the outset, but they could be split up 1, 2 maybe. Which to me, okay, listen, maybe they got the raw deal on the parents' end of it, but now they don't even get their brothers and sisters, and so at any rate, so the consequences of your actions don't matter.
What's the cost benefit?
What?
What's the cost benefit?
But there's no cost benefit to you, right? You're just getting your money.
But I'm saying DSS, or what is it called? They're going into that home for a reason. Right?
Well, this actually didn't involve, mine didn't involve DSS per se. The children had been placed with us for many, many years, and then when we moved forward for adoption, the whole thing blew sideways. If you have any Native American blood, the Indian nation has to be notified. It just turned into like something almost beyond belief. But so you started to say, so at the end of the day, you're in, right? You didn't know necessarily at the outset, but now you're in. And so your consequences of that, your consequences are you're going to bankrupt Al. And maybe Al's not such a bad guy as it turns out, but if you win your case, he's bankrupt. Or you're going to take the easy ones, that you're going to get that child molester or rapist off. I've told you in the past, I think I've said to you not in this class, but my brother is a criminal defense lawyer up in Maine. My sister's a teacher, and he was in the DA's office for many years, but then, as most DAs do, they become criminal defense lawyers, and he would move to suppress trunk loads of drugs from illegal searches down the Maine Turnpike. They're the people that paid the bills. And the searches were often bad. So the drugs were suppressed, there's no case left, clients are happy, drugs are seized, so they're off the street if you want to look at that from a law enforcement standpoint. But he makes a lot of cash, and my sister wants to know how that drug dealer then could be allowed to go bring those drugs to other school children throughout Maine and Massachusetts and New Hampshire and everywhere else? How could you live with yourself, I'm sure? Well, no, based on how dramatic my sister is, no doubt that was probably the least of which came out of her mouth. But you don't care? I mean, there are consequences to all,
I was gonna say, I think if you look at the silver lining to any bad situation, so that, taking your example which you just gave, the silver lining could be that you're now making the police department that wrongfully sees the drugs, you're giving them a higher standard than they have.
well, listen, it could get worse, right? Maybe the next time it'll be a tractor trailer full of it. You better figure out what you're doing and get it done right. And I mean, they do have an obligation to comply with the law too. But what happens when the situations are worse? It's not just the trunk full of drugs, it's the rapist or the molester or the murderer even.
Well, in that situation, I mean, yeah, sure, you're breaking the family up, but the cost benefit is you're possibly saving a child's life, because molestation, rape, that's one level. It then gets deeper and deeper where it gets more aggressive. So, I mean, yeah, you may break them up for the time being, but you're also saving them from a lifetime, possibly a shorter lifetime, of a lot of mental, issues and whatnot, and possibly them turning into a...
So is that what we're going to do? Is we're going to rationalize that maybe this is a good result? Which is okay. I mean, because at the end of the day, you've got to sleep on your pillow, right? So you got to figure out, did I really get it right? Or because am I just a lawyer who's indifferent to the consequences? Because a lot of times what we do has significant consequences. And I think Colin's right. A lot of times that's what you try to do is look at the positive side. There's got to be good, the good part of it here. But here's the problem. You're going to win some cases you shouldn't win, and you're going to lose others that you should win. And then you think, then they got it all wrong. And so even if I thought I had the right side, well, now they've really messed up. And now,
Well, then you don't have to blame yourself.
Yeah, right. That's right. Then I have a whole other group to blame.
So in taking the defendant's case, should we really be thinking this through, how in our mind it might work out before we defend somebody like this?
I'm asking you, I guess, when you take that case, are you thinking, do you have to think, or we don't care? That's what I'm asking you. Do you care what the consequences of your being successful may be, or that doesn't factor into it?
Because the number one thing I hear from people on the street, so to speak, is that they despise lawyers because they get these type of people off.
Well, you have an article, that was the next jump, it says lawyers in their games are leading us down the tubes. So that is the next one I wanted to ask you about is, there's a lot of people who don't like you and don't value what you do because they see you as mercenaries equally able to fight for either side. I always say they hate us until they need us. Yeah. And when they need us, they love us. And that is our lot. So we can cry about it, but we're an easy target. So, but a justifiable target? I mean, you're really no different than a paid assassin.
Not as bad as police.
Huh?
It's not as bad as I guess I wouldn't say it's as bad as how people might be towards the police department sometimes and stuff. At least we're not standing out in the open where they are. But I think they have it rough.
No doubt, and we can cry about our situation, but there are others that are in the same boat. Law enforcement until you need them. But I wonder who people hate more, whether it's lawyers or police officers. I think it's lawyers. Lawyers. So wait a minute though. So my question though is it justified based on what you're telling me as well? Listen, it doesn't matter what happens. That's not my job. My job is to represent my client as best I can within the bounds of the law and the rules of ethics. And if stuff happens on the end of it, that's not on me.
That's what we're taught to think, though.
But it's, should you be? That I guess is what I'm asking. Should you be? Is that our fault then? Because if that's what we're teaching you, is that wrong?
Well, wouldn't every allegation then just be nonsense and everyone just get thrown in jail?
No. I don't mean that. I'm wondering if, and this is really what I'm wondering and asking you, is there a way to balance some of this? It doesn't have to be, okay, on every child molester, I'm taking a dive and let him go to jail. Do you ever see Cape Fear? Because if you haven't seen it sometime, watch it. It's scary as hell if you're thinking about taking a dive and giving them less than a full effort of your talents. I'm not suggesting that. I'm wondering if there's some balance here. Should you at least think about the consequences? Should the solution, maybe the best consequence is to counsel your client. We can do X, Y, or Z, or I can try and get you a better deal, or I can get you a better deal in treatment. What about that? So the abuser comes into your office and says, I'm going to beat the crap out of Marguerite again and again and again, and she won't ever show up in court because she knows better. So here's a pile of money, defend me. You just pull in your little pile of money and say, repeat business, right? This is going to be good for the kids' college fund, or maybe try to direct them to counseling, to try and direct them to a deal that maybe will benefit both the batterer and Marguerite, your conscience, your ability to sleep at night, not worry that one of these nights someone's going to call you and say, Marguerite's dead. You feel good about that?
Can I just?
Yeah.
All right. Before coming to law school, I used to be in victim services, and we would watch, this was in New Hampshire, we would watch, defense attorneys come in, find the victim sitting alone with nobody around, and then play their little game of, I'm really here for you, really here for the family, and get them to reveal all this information, and then put them on the stand and just rip them, and it was horrible to see, and easily responded to. All it needed was somebody to say, you need to understand that he is not hired by you. He's not here for your interest. This is what's going to happen. But even then, people just wanted to believe that attorneys are truth tellers, and they're ethical and moral, and they're of a noble profession. And if he says, the man in the suit with the power tie, that he's going to help my family, then he's going to help my family. And it was a disgusting display, and I think it absolutely falls on us to ensure that we don't behave that way.
But how do you not, right? If I'm representing Al, and I can talk to the victim and say, he promises he won't do this, he'll do X, Y, or Z, we're going to try and set up counseling. If you don't testify, they really can't go forward. Do you want the father of your children to go to jail and not be able to pay the household bills and see him suffer like that? But
it's just so easily done, and you don't have to do that to represent your client well. First of all, those cases are easily winnable without even doing that.
But wait a minute though, they are, but you guys going to leave some stone unturned that might benefit your client? I don't disagree with you, they could be won otherwise, but I thought we've been talking about in for a penny, in for a pound.
Just a notch of integrity. You don't have to directly misstate or not disclose your true
we're trying
purpose.
to give them the
I'm
message.
here as a representative of your husband. This is an offer, like a bona fide legitimate thing for you to consider, but make no mistake, I'm hired by your husband. You can get a similar response and have some integrity about you.
Well, yes, but no matter whether they say, I represent your husband Al, I just want to talk to you a little bit about the situation. He's talked to me, he feels very bad about what happened.
Okay, lie.
No, he said he feels bad. He feels bad about where they've ended up. How about that? He feels bad about where they've ended up today.
I feel bad.
He doesn't want to go to court. No, but you guys told me you take the words and you sort of mash them around till they feel right. So wait a minute though. So can we do what she's suggesting? Can we sort of balance this? Or is it knock down, drag out? I know she won't stand up to cross, or even better, as has been suggested, I'm going to go get a little information to help fuel my cross before I then rip her apart on.
And how long does that go on for? So the next time it's a battered wife or whatever, and Al has to hire another attorney. Oh, Al feels really bad about this time, just like the last time. I mean,
But the history.
We know
Is
the
that this
history,
is the cycle.
Yeah, but I mean, to the point, to I think her point is, do you continue to manipulate the victim?
Well, you tell me. That's my question. That is the question for today. Is how far out do you play this? Because the consequences, ultimately, we know from past experience, are potentially can be more than severe, right? So do we tell Al the best thing to do is plead, batter his program, and get yourself some serious help? Maybe even stick him on probation for a period of time, so if he does hit her again, it's a
I hired you guys.
quick disposition to jail. But wait a minute though. You know, sort of here, that if you try it, that's not going to be the disposition. To try it, likely we're looking at a not guilty. She may not show up. She probably won't, especially if it's a rigorous cross the first time through, right? So you're just being used as a pawn in the whole process. Or I guess, saying you're a pawn means someone else is using you, but you're much more evil than that in this scenario given, right? So, but so that's okay to just simply cloak that under, well, it's just my job. I've got to zealously represent my client within the bounds of the law. So back to, is there some way to sort of balance your role, as many people see you as the community leader, the representative of what should be right, to somehow be able, because people do listen to you. You have a voice that's more powerful than most. So is there some way to sort of blend some of who you are with some of your role as a lawyer?
Isn't that the great thing about mediation, where you can reach a balance?
Thank you.
Yeah, it is if people want to do it. But again, in the scenario we've just talked about, the likelihood is I don't need to mediate anything anymore. I've got what I need, right? Go ahead, Marguerite.
Al, come on, you've got, a domestic violence victim in intensive care, and you're really going to tell that victim, go to mediation, that's better than the ugly court system, that'll be better for your rights? Give me a
Work out
break.
your differences. The equal balance power.
But so then help me with this. How do you align this? Because there will be clients you will end up representing who you won't trust or like, and will fear the consequences of success. So, do you give them a boot in the ass? Can you do certain things? And I guess even more important globally for you to start to think about, so where are these lines here? What, are there certain principles? I think the question I post for the online people, whatever the number, 3, 5, 10, are there certain principles, lines that I'm not crossing as a lawyer? Things that I think are essential principles to how I will conduct myself as a lawyer, as the officer of the court, as what many people see as a community leader, someone whose judgment and wisdom are important. Are there certain principles like that? You nod your head and you say yes. I'd like you to write them down. I'd like you to email them to me, because the online people have to, because I'd like you to think about it. Because I think it's a very serious question and an important problem. And I do think part of this is our doing, because, we tell you that you should be able to argue both sides, and that you should zealously represent your client within the bounds of the law, and that it's an adversarial system. But at the end of the day, at our best, we can accomplish a lot of good. at our worst, we can really accomplish a lot of bad. And so, how do you intend to conduct yourself such that the latter doesn't happen to you? Or because I think sometimes you minimize the ability to sleep soundly at night with this wake of carnage behind you. You know? And maybe you can, because there are ways to rationalize it. It's not, I am paid to be the advocate. Guilt or innocence, liability or not, that's either the jury or the judge's role. But get Gifty.
I think we are human beings first, and then attorney second, and the rest of it follows. So it depends on the case. It depends on the client. If the client has repeatedly abused or wiped the kids, and it's gotten to a point that it's getting into, maybe once is pardonable, twice you might get some punishment, and I'm going to turn my defendant, like my criminal defendant, okay, the first time it was just a slap in the face. The next time it might be a gun in the head. Therefore, you need this help. I mean, I'm going to balance it that way. You need this help because it's happening over and over again. And we can save the kids from abuse, or like, I don't know his name, what he said. Colin said, future psychological problems down the line, or they might end up becoming abusers in the future. So for that reason, the balancing will go, whether it's the first time or the second time or the third time. We cannot repeat this, and that is me. As a human being, I wouldn't want anybody to spit in my face. Once, if you do it twice, I'll slap you right back in your face because I'm that violent. But the first time, I think is pardonable, so I can go in jail and serve some time.
The only...
I have a question.
Go ahead, Louis.
Assuming I'm representing a client, and the client told me the story, the version of his version of the incident, and then I realized the client lied to me, like happened to you in one example you put it. Can I tell the judge I don't want to represent that client?
You can try and withdraw, but the court is not always going to allow you to. I want to talk about her depends, but I want to talk about your lie. As I have practiced law longer, I now have a better appreciation for what I would see as lies, and I think to the extent the client doesn't see it as a lie, they see it through the prism of their eyes. This is how they perceived it. This is how they understood it. You must have fought with a partner at one point, right? And you're damn sure you are 110% right. You did nothing wrong to instigate the argument or whatever. But you know what? He or she sees it just as differently as you do, that you were the instigator and you did X, Y, or Z. And the more I practice law, the more I've thought of this problem, I think sometimes it's not as much, for some, not as much an intentional lie as this is the way they saw it, and it's not really the way it happened, but that's the way their memory now has it. The problem is, and so it's not as clear, because to me, if I knew you lied, that I have a lot easier time cutting you free and moving on. But the problem is, from experience, and this sounds incredibly cynical, you never get the truth at the outset. There's always his story, her story, and the truth is somewhere apart. And it's whether, it doesn't make a difference, his or her, it's a business dispute, it's any type of case that you have where there's really conflict. It's not as, you don't see as often people just boldly lying to you as much as omitting key facts that would be important, that could even be dispositive, but they just will say they didn't see them as important, or maybe they didn't remember them, if you want to give them the benefit of the doubt. And the other part is what I call, what we say we do all the time as lawyers, coloring the facts, putting a slant on them so that it's the way I saw it. It makes me look better if I give you my version of it, And so that's the problem, is in a lot of these cases, you're kind of far down the road where you then realize that if you want to say you've been had, because that's the way you feel when it's been happened, is that I was led to believe one thing, and it's just not true. In some, the one I think you talked about, I have no doubt that was just lies from the outset. But that's a lot rarer, and so frankly a lot easier to deal with than the ones where the facts, are changing as we go, and they're never, it's not as clear that it was a deliberate deception. And it probably wasn't, I think, now from experience. But you can ask to withdraw, but there will be times where you won't. The other part of the problem here is, from a realistic standpoint, is, well, you've been paid tens of thousands of dollars perhaps, or your recovery is based on a percentage of what you're going to get. And, now we're withdrawing over conflicts with the client, so we're giving the money back, or we're foregoing any percentage of the recovery. I'd like to tell you we're all rich enough to say, you keep your damn money, but in the real world, that's that's not an easy call, right? Let's get out of the classroom and be realistic. You have bills to pay, you have clients or other partners or people who are looking for that money, you likely already spent it, and so now what do? I'm not going to refund you the money. I've earned it, but you're going to ask for it in all likelihood, and if you don't get it, you're going to complain to the BBO. And the problem is, if I can't, if you can't show it's a lie, then why are you withdrawing? Because it's just not quite what you thought. And by the way, I think at the court, because this offends you, right? This is offensive to your character or morality. Thought your lawyers didn't have those issues. No. What about, okay, let me ask you, I would like you to do that, but let me ask you about this article. It's an older article now, but nothing has changed. Lawyers in their games are leading us down the tubes. There are too many of them. There are too many opportunities for them to create mischief. They exact a tremendous toll in fees, delays, canceled business, and ruined private lives. And the good they do in many cases seems to be outweighed by the friction and drag they impose on modern American society. Boy, you guys are like those heroin dealers, huh? Nothing, this is just our lot in life, that too many people see us as drags on society. Huh?
I think we have to clean things up a little bit.
So how would you do that? Because I sort of got the impression from the discussion we just had is that it's awful hard to balance your sense of morality or justice with your role as a lawyer. Because your sense of justice doesn't matter, I thought, when we've had this conversation before. No?
You set those character rules, those the model that you want to follow, and always follow those.
So what is that though? So what is the, because so now your sense of right or wrong is going to dictate? Do you, as a lawyer, you're going to tell me, Mike, maybe you really shouldn't get divorced. Mike, maybe you should have more children. Mike, maybe you should give more to the church. This is what I'm paying you for? No?
Yeah, we are counselors. The name.
I'd like you to be a counselor, but so that's all okay? So now it's Sister Gifty?
Yes, Sister Gifty.
No, is that okay? Because I could hear someone saying, so especially someone smart mouth like me could say, I paid you to be a lawyer, not my priest. Right? No?
Yeah, someone would say. Well, you know what my family told me, like, Gifty, you're going to law school, United States, and I'm spending thousands and thousands. Here might be a little change. My brother told me this could build like 3 hospitals in my mother's village. You don't have to go and come back and lie to everyone. Your Christianity is going to go down the drain. They told me, in fact, yeah. The money is not, it's not important for me to invest in that kind of education, for me to end up becoming, in Ghana, it's like we're all liars. Same thing. It depends on where your client is. If your client is right by your morals, I have principles, I have morals, upbringing, ethical things that I know I'm not gonna be party to that defendant. I hope that my criminal defendant will not go that way. But I'll tell them that I cannot let you go free this time. These are the consequences of your actions, and I think every criminal knows when they pull the trigger or when they started hitting the girls or drinking and driving, whatever they've been doing in the past, they know. So I'm not here to
They
be your
may
mom.
know it, Gifty, but by an overwhelming majority, people in prison have been wrongfully convicted. Up here. But what I
In a
mean.
nice way, in a nice way.
I know, but that's not the way necessarily they see it. And if you listen, right? If we were in prison, wouldn't we want to get out? No? Okay, so one way is to say I didn't do it and my lawyer was bad. So, from that standpoint, people don't take responsibility
You're
generally.
going to be in there for 10 years, and we as well
10
can help
years.
to bring you to 5 years. Because a crime has been committed, so we can try to bring you closer to getting you out. But you still have to be in there for a period of time. Or
Do you think you could win the case if you went to trial?
like you said, I might lose a lot of cases and I'll win some. But when there is a lot...
Wait, but you're not going to lose them on purpose.
Not on purpose, not on purpose.
So if you thought you could win, would you still tell me that I should be thinking about doing 5 years because it's the right thing to do?
No, I'm talking about people who deserve to be in there. There are people who deserve to be in there.
But
There are people who deserve, like, I think I'm going to choose, I'm not going to be a trial attorney. I don't think I can do it. I can do it, but even in mediation, I think there are people who deserve to be told that really you deserve to.
We can't give them our best defense then?
Our best defense.
We can't be their lawyer?
Because you were saying it's so hard for us to tell them in their face that you're wrong. There has to be a nice way to tell a criminal defendant that you were wrong because of the elements involved.
Oh, I think you can tell them they were wrong, and you can even say, you should go to jail. But it's the next step that they're not going to be willing to take. And so, put me in jail when I think you can keep me out? Yep.
My brother's a criminal, like, to the books, and like listening to him talk, and a lot of the people that he deals with, they have a really big entitlement issue.
Oh, yeah.
So it's always somebody else's fault. So you can tell them 15 shoots to the wind, it's your fault, you effed up this time. My brother's been to jail like 8 times now, he's younger than I am. And the 8th time it was still, well, he shouldn't have been, he did something wrong. I'm like, no, you did something. But they're not gonna listen to you because a lot of them, like from what I've heard, especially talking to him and people that he's around and stuff like that, it's always somebody else's fault. They were caught because of somebody else, or someone else provoked them to do what they did.
People don't generally take responsibility for their actions, whether it's criminal or civil. It's very rare that when they're caught, again, civil or criminal, that they pony up right away and say, okay, do the right thing, put me in jail, tell me how much to write the check for. But that's why you have business. Right? That's why we all have business. But that's why and so, by the way, Gifty, when you tell them that, I think Allie would have told you, you're not going to have a client long.
No, I'm going to try.
You're going to try what?
No, I'm going to.
Because they're going to say, see, I'm going to go to Al. Oh, I'm going to go, better yet, I'm going to go to Lewis.
No, Lewis will take the money and help you out. I'm trying to bring cases that, to me, morally, I will not be able to be a party to that. That's what I'm saying. There are cases that I'll try and defend. Like we talked about on Tuesday about immigration.
Yep.
Being an immigrant and knowing what is going on, I would not be able to be on the part that will send everybody away. I'm not a criminal and I'm not a citizen. So supposing this summer I'm going home and I'll not be able to return, and my law school and my brother says $60,000 is gone, and I'm back in Ghana. And so I
Well,
will
immigration lawyers are saying you probably shouldn't until this gets somewhat
Yes.
squared away, right? That's their legal advice at this point.
Yes, but if it's so important that I have to go, maybe for an emergency. So what I'm saying is that in a case like that, it will be hard for me to be on the side of the government.
Yep.
But if I am in a situation where there is a real criminal from Ghana who is doing drugs, stealing cars, shipping whatever doesn't belong to them, and the person needs to be reported, yes, I'm all for it. I'm going to let you know that, well, you were Ghanaian living in the United States, stealing and using guns and drugs, and therefore, for whatever you did, this is what you deserve. But I might try to bring you closer to living in here. I'll try to mitigate your crimes for you, bring it down a little bit. But for that, I think
It's going to be a challenge.
it's going to be a challenge. But I don't think all my clients are going to be that way.
And some of the internal turmoil or conflicts that you might have, you can remove or eliminate simply by choosing the areas that you want to practice in. Right? I mean, if you think about it, obviously one of the bigger areas is going to be criminal cases because of the nature of the work and the nature of the people that are generally charged. No one wants to go to jail, but most of them have committed the act. The question is the government going to be able to prove it? And there's some that obviously are wrongfully charged and all, but the problem is you may well, in a lot of your cases, be putting someone back out in the street who potentially poses a danger to others in society and the like. And so you have to deal with how do you balance that, or do you say, not my job, and that's, go ahead.
You could also look at it as like humanitarian, like second chances.
Yeah, right.
Like
You can
a
believe the best in
rational
people.
What?
Al's not going to punch Marguerite in the face next time, even though he said he probably would. No, right? You could. We could sort of blink it away. The serial batter, now I've given him a good talking to. He's going to change up. No, but you listen. And again, we play. I don't mean to minimize it. We play this game with ourselves. Not my responsibility. I said, Al, don't do it anymore. And he looked me right and said he won't. But he won't go to the batter's program. He won't do these other things because he doesn't have to, because the court won't mandate it, because there's no guilty finding. We know how that repeats itself. Same thing, I mean, you think about it. Same with drug dealers all of a sudden going to stop dealing drugs and they're going to go to MIT and make a fortune, right? I mean, if you think about it, that criminal law, but I can tell you from having done civil litigation for decades now, you get similar issues, because criminal law, at least you know who the bad guy is supposed to be. Civil, it's civil, you don't always know, and sometimes you're down the road and then you say, this isn't quite the way I thought it was. So I want to take a look at first technology safety systems, because I think there's shenanigans going on in this case that are worth thinking about. Because here, at least one could argue that they are using the litigation process to further the business interests of the client and not completely in an appropriate fashion. So, because when you look at this, I think you should start to ask yourself, okay, it's one thing to take the case, it's another thing then to move forward aggressively. Oftentimes in business disputes, that's what they need. But now, how far down that road do you go in using the litigation process to further your client's potentially inappropriate business needs? And we see this also with non-competes and things like that, where there's a rush to get injunctive relief and the like, and one side may be woefully ill-prepared and ill-financed to be able to defend the suit. And so just even bringing the suit and undertaking certain actions is a crippling death blow to the other. And so here what they did is they sought an ex parte order to impound certain evidence, as they saw it, that the defendant had in its possession. And so, First Technology filed a verified complaint. We talked about that under Rule 65. You need a verified complaint if you're going to seek injunctive relief. They were charging the defendants with unfair competition, unfair trade practices, conversion, receiving trade secrets, interference with the contract, and at the same time the complaint was filed, they sought an order for seizure and impoundment of evidence. And this is something you have to think about now, right? Again, it's improper. You have an obligation to preserve evidence. I'm going to talk to the students who are taking the bar exam next week about the Massachusetts cases on spoliation of evidence and the like. You have an obligation to preserve evidence, not just when suit is filed, but when you know that suit is likely to be filed. But, you know, today, in this day and age, we hit delete and it's gone. If I know you're coming looking for the customer list I stole, I'm likely not going to keep it on the computer. If you want the crash dummies that I took from the company, I'm not just going to keep them in the building when I know now that you could be coming for them. So the seizure of evidence, especially when we start to think about electronic information, and hard drives and things like that, become a really important question about the preservation of evidence if we're going to be successful. So what they sought here is the temporary restraining order, seizing that information, and then allowing it to be held by the marshals until such time as it could all be inventoried and determined exactly what they took. And so what happened here is that it would appear, at least as the plaintiff saw it, that the only way they could have got up and running as fast as they did is to take proprietary stuff belonging to me, which, I mean, it's business, right? This happens, unfortunately, a lot. Same thing when you think about someone violating a non-compete. They've taken their customer list, they've taken whatever it is they need before they say, see you, I'm out of here. But now they've got potentially confidential and proprietary information, so they can very quickly set up and compete against me, costing me potentially millions. It didn't costing me potentially my business. But so what happens here is that they sought an order from the court to get a restraining order to impound and seize the evidence in the case that they believed would belong to them and had to be taken from them. And so what happened here then, and it gets kind of funky, but I want to ask you about whether, to what extent the plaintiff's lawyers improperly then benefited from what the marshals' sloppy work here. It said the order authorized the marshals to impound a variety of items that could be identified as belonging to the plaintiff. Blueprints, computer printouts, programs, documents bearing the name predecessor, also inventorying the inventories, copies, the invoices. What we're looking for is what stuff did you take from me that you shouldn't have that shows that you were going to use my own information to compete against me. In essence, they've got this temporary restraining order allowing the marshals to take that information and seize it, at least until the next hearing. And they had to post a bond, and we'll talk about bonds on temporary restraining orders down the road, but a $2,000 bond isn't going to kill any business. And so then what happens at 5 p.m., the marshals go in, they have plaintiff's counsel with them, they have local counsel with them, so they have a computer consultant, which wouldn't be unusual at all either. They set up the coffee machines. The marshals then left the premises, and so these guys, the plaintiff, had the run-of-the-mill of the defendants premises at that point with all the information that they were seeking. And then somewhere around, said at 11 p.m. they all left. And then the seized materials were held in trust for the court by plaintiff's local counsel because the marshals said they had no space to hold those materials. Geez, they're giving the plaintiff's lawyers an awful lot of leeway here to both access whatever information they want, copy it, and then to sort of store it when it should be the order of the court having the marshals do it. I guess my first question in with that is, well, is that on you as the plaintiff's lawyer if the marshals are going to let me stay there till 11 by myself and let me store all that material in my premises? Why should I be raising red flags? This certainly benefits me from the standpoint of my client. It gives us a significant advantage in litigation, even though it doesn't, to me, it doesn't pass the smell test. Is that my job to raise that issue? I mean, I could even see myself, well, maybe not, saying, do you really want to do this? Or are you guys really leaving? Or why, do I even need to say that? So it's not on me if the thing gets all messed up, huh?
It's very suspicious. They convenient left, the marshal left.
No, it's 5 o'clock. No, really, seriously, it's 5 o'clock, we're done. No. I know it sounds convenient.
Legally, he didn't do anything wrong. I mean.
No, right. My day's done.
The marshals were.
Right? My day's done. I'm not staying after 5. And frankly, as a plaintiff's lawyer, I'm not going to pay you to stay after 5. Go ahead, go on your way. I can do what I need to do without you here. I can do a lot more of it without you here. That's on me to point out that those who are charged with doing something appropriately are not doing it when it benefits me? Because it seems to me that the plaintiff's lawyers are taking advantage of the situation. Okay. Is that okay? I mean,
I'm trying to.
Why is that on me to straighten out? Okay, I'm the plaintiff's lawyer. I'm benefiting by someone else screwing up. Why should I have to not just be the adversary, but now I've got to be the regulator, now I've got to say, hey, you helped me out way too much. Maybe you ought to do something. I'm just following the orders that the court gave me. Is this? Does this seem problematic? Because as we look at it, it smells a little fishy now. So you're still going to have to explain at some point to the court what happened here, but these are practical problems. You know, okay, I've got a seizure order. I've got documents that will fill this half the room. Who the hell are they going to go? Right?
If at that time, 5 o'clock, the defendant called his lawyer.
Yep.
And says, what should we do now?
Well, right, so that's on now, and so he calls Al, and Al says, well, go home, don't worry about it till tomorrow. That's not on me.
And then the other...
Right? That's not on me as the plaintiff's lawyer. If the defense lawyer's not saying, well, I'm going to go in right away and get an order, or I'm going to say, if the marshals leave at 5, you leave at 5. Or the defense lawyer could say, I'll be right there. How am I responsible for the screw-ups of some other lawyers?
And if he goes there at 5:30, what can he do? What can the lawyer do?
As a practical matter, this is a real screw-up. Because what can you do? I can yell and I can threaten. I can take pictures. I mean, I can make like I'm doing something. But what I really could do, if I wanted to, is go in and get an order from the court. But that requires real work. So you could at least investigate what's going on. Because, I mean, you've given them run of the place. And now any lawyer is going to be a little tempted to turn the page a little further than they might have otherwise, because you never know what you'll find. So then let's say it says that same day. So on April, they filed a motion to vacate on April 16th. So that's 8 days later, where they've had all this material. And you know, I've been in that situation where they've given me access to the room and said, okay, go ahead, copy and tag whatever you want. And when I'm in there, I'm thinking, they shouldn't have said all of these documents I didn't even ask for. But then I'm finding stuff that's in there that's important. That's not on me to say you screwed up. If you're sloppy or lazy on the other side, that's your own damn fault. Isn't it?
That's how I saw it.
Well, I'm just asking and showing you, I think these business disputes, a lot of times, and especially with non-competes, it comes in with a bang like this, a flurry of litigation, a flurry of activity. One side has significantly more money than the other, and what we're doing, and this is what I'm asking you about really, is using litigation as a business strategy, trying to crush the other side before they know what's going on, and winning quickly because of superior lawyering, resources, and legal position, or just money? Or do I care? So my client's got lots of money. They can have their lawyers, they can have local counsel, we can go in, move quick, move hard, move fast. Why do I care that the defendant doesn't have as much money or resources or even skill? Because that happens too. Because that's not on me or you, is it? So will you use litigation and the speed with which some of the injunctions and things like this sort of ex parte seizure orders and the like, in order to advance the business interests of your client?
Yes.
Okay. Why not?
It's not the purpose of these kind of injunctives or impounding, or it's not the legal purpose of it. It's not what it's there to do. You're really stepping outside of the intent of the law as it's structured.
I thought I was trying to win. And I thought I've been told from time to time that's my job. And if I can crush you hard and fast quickly, because we have more money, personnel, and the merits, we've got to have some merits, great. No? Or do I have to say, Al doesn't have quite as much money, we ought to take it slow? Because that's not the client's desire in these business situations. It's to crush quickly the other side. And this here, to me, this case reeks of, and by the way, from the business standpoint, the plaintiff was feeling that these two bastards stole my stuff, stole my business, and now set up shop across the street and want to compete against me. Damn right I want to crush them, and I want to crush them fast, and I want to bankrupt them if I can. Right?
You're being paid to win. You're not being paid to be friendly.
And this isn't going to be friendly. You stole from me, right? You stole my property to compete against me, to steal more from me.
I don't think there's a morality issue here. I think the lawyers are in their right to try to win.
So what? Shock and awe. Right? So we're coming in, we're coming hard, and if we can get the court to agree to give us these orders, that's not on me, that's on the court. And if the marshals don't want to do what they're going to do, again, that's not on me, that's on them. And if the defendant's not going to advance the arguments they should and object as they might appropriately, it's not on me either. My job once in is to move forward aggressively and quickly to the extent that benefits my client and win. And by the way, the converse is true, I assume, as well. So you're defending. My job is to slow it all down. And if that's what I need to do, that's okay too?
Some clients will sue you for incompetence or...
No. Oftentimes that's precisely what the defendant wants. Slow it down. Every day I keep the dollars in my pocket as a victory. And so, be represented by the law firm Stall, Hinder, and Delay. I think, and I'm going to leave you with this as you start to think about this whole technology stuff, adds a whole nother dimension as we start to think about preservation of evidence using litigation to advance those interests. I think there's a lot of legitimate issues with how easily the evidence is destroyed or lost. So it's not uncommon to seek injunctive relief to prevent the spoliation of evidence and the like. Obviously, and this goes without saying, but I'm going to say it, you can't be part of any destruction of evidence, and you have an affirmative obligation to make sure that your client's aware that they've got to preserve evidence. You know, the fact is that, I've said to you before in other contexts, the first person under the bus is you. So when you tell them they can get rid of this or get rid of that, or geez, that's a really bad series of documents, or you better dump those crash test dummies in the dumpster, in someone else's dumpster really fast. First person that goes under the bus is you. And to the extent you've been involved in spoliation of evidence, there's a separate suit against you, but you're also going to have to account to the Board of Bar Overseers as well. I think there's a balance between our role as advocates and making sure that we don't become part of the combatants. And that balance isn't always easy to reach, and I think it gets harder sometimes in a case like this where, you know, I sort of agree with Al, is that it's not my job to police the marshal. It's not my job to tell the defendant what they should do to prevent me from succeeding. And at the end of the day, someone else has to do that, even though I think the plaintiff benefits greatly in the early going here by the incompetence that's around this case. And ultimately all the evidence was transferred, but we lost a lot of time here, and you don't know exactly what might have transpired in that period. Maybe so you don't look like you were doing something inappropriate. You could have been a little more proactive, but at the same point, if I've got all the evidence I now need, the case may likely be over, more likely than not. So, and I want you to look here, it's on page 650 of the book, of the decision, where they talk about ex parte jurisdiction and the like. It is rare that the court is going to give you an order without notice to the other side, and that's what ex parte means. And it runs counter to the notion, if you look at this page, that someone should get reasonable notice and an opportunity to be heard, which due process guarantees. And the court is also aware that as a practical matter, orders that are issued without notice to the other side are issued with a very incomplete version of the facts. When there's someone else there, the moving party won't be as free to interpret the facts in their favor as when there is some level of adversarial hearing. Do not seek ex parte orders lightly, because the court's oftentimes going to tell you, do they know you're here? They're going to ask first, do they know you're here? If they don't know you're here, why? Can you really justify an ex parte order? The notice may not be the customary notice, the summons to them in hand, and then they have time to think about it. Sometimes the court's going to want, can you give them a phone call? Can you give them a letter? Is there some way to at least get them within the courthouse so that we can see what it is they would tell us with it? Ex parte justification really should be where there's no practical way to give them that notice, and if we give them notice, like in this case where they've already stolen equipment and supplies and the like, that they might either steal more or trash what they have in order to cover up their activities. That's what you've got to show, is that they'll hide, conceal, destroy, or do something with what we're seeking in the event they're notified in advance. Don't go in lightly thinking that just because TROs say you can get one ex parte, that the court is likely to take whatever you say at face value and grant it. It's more often than not they're going to want to be able to hear from the other side. I will talk to you next time.
Thank you.
Thank you.